Good evening, ladies and gentlemen, friends and losers. All the losers who are habitual like me, and the losers who are sore, who are graceful, and losers of all kinds. I'm Shruti Khanijow. With a brief introduction about myself, I think we'll know why I chose the art of losing being a disputes resolution lawyer. I work in corporate disputes. I handle large disputes in complex, complicated, global matters and cases. I assist my clients in preserving value, in resolving risk, in optimizing outcomes, and at times also understanding loss. What I do very often, I'm not paid to lose, but as in life, so in law, loss is inevitable. So today, allow me to walk you through this art of losing and share some of my lessons from the litigation trenches. I started off by telling you that I'm a corporate disputes lawyer. Now, the image of a corporate disputes lawyer, the moment I say disputes, would be something very similar to what you see in Netflix. All the Harvey Specters who like life like this, where the ordinary life is here. All the Alan Shores for all of us who are quite old. All the Denny Cranes, all Alicias from The Good Wife are the common narrative when we talk about corporate disputes. And it's a common perception too that lawyers don't lose gracefully. When you imagine a lawyer losing, the first thing that comes to your mind would possibly be banging their hands on a corporate conference room table, or going ahead, possibly looking very upset, throwing some papers here and there, driving a car, looking outside, looking through the wind and wondering, why did I lose? The last part, of course, is correct. So allow me today to take you through my journey of how law defines a person's ability to navigate losses, how a loss in law is not a loss forever, and how these setbacks are considered to be just a small halt in the long journey of what remains in the larger battle. So again, in disputes, specifically corporate disputes, what does loss really mean? It means money. It means the amount that I lose while pursuing a case. That's a loss. Time. Delay is the enemy, the larger enemy of any corporate dispute. The time lost is also cost, escalation, and money lost. Reputation. Your trust and your belief with the regulators, the investors, over a period of time does get impacted the longer you are engaged in a dispute. So that, my friends, are loss. Precedent. Principally, if you do work with multiple stakeholders, including, let's say, vendors, regulators, the government, and you set a precedent by going into the wrong war, you are setting a precedent of yourself. Now, let me give you an example here. You take on a specific vendor because of an incorrect clause in your contract. That clause is something you had inserted. Let's take an example. Every time you deliver a bale of cotton to me, that time itself, I will have some money paid to you. But all of them in 1 rupee coins. Now that does sound unreasonable, doesn't it? But if my vendor refuses to take those 1 rupee coins for a 10 crore consignment, I sue them. Well, that is unreasonable, isn't it? That does sound ridiculous. But the cost of that ridiculousness and the correctness of that contract is not going to help you, because you're setting a precedent, getting into that specific dispute with all your vendors, all your suppliers, all your investors, that this person has a history of getting into disputes, and that's not really fair. Enforceability. Now, loss really translates a lot heavier when you pursue a case, when you pursue a litigation for a long time, and that pursuit of litigation leads to a paper decree. Now, what does paper decree mean? Paper decree means you have won the battle, but you have lost the war. There's nothing you can do with that award or a judgment except just look at it, hang it on your screen, look at it every time that yes, I won the war, but I got nothing out of it, not a single penny. So in terms of corporate disputes, that's what we call a loss. Now there is other thing, the curse of performative litigation. As a lawyer, a lot of my clients, like I said, do not pay me to lose. At times, I can go ahead, please my clients, or dispassionately, what's actually required of me as a lawyer, tell my client that these are your rights, these are your liabilities, looking at the long term, this does not work out for you. So now let's take a step back and let's put that example in real life. You go ahead, somebody bumped your car, you don't like it, you're very angry, you go find out who did that, you pick up a fight, you have a good wrestle with them, everybody's hurt, people watch that, nobody's happy. Now that was performative act of battle. Similarly, like I said, in litigation, when I tell my clients this lawsuit is not worth pursuing, please let's look at this defeat in the shorter term and take the proceeds and see what better can we do with it. That's the place where we look at the success of a small settlement or non-loss in a larger magnified term. Now, when law changes its mind, it's a very important aspect that we want to highlight. Over a period of time, you'll see, as societies change, the courts also look at the changes in law that way. So if you're losing a case today, and we look at the examples also, does not mean that the same situation will continue forever. Let's look at section 377 of Indian Penal Code that decriminalized homosexuality. In 2009, there was a case called Nas Foundation, which the Delhi High Court held that section 377, which means same-sex consensual intimacy, was decriminalized. It was no longer illegal in India. This was a celebrated judgment, but regardless, after 4 years, the Supreme Court did not think with the same wavelength, with the same policy considerations, with the same interpretation of law as the Delhi High Court did. And section 377 again was criminalized. Now let's look at the next victory that happened within a period of the next 5 years. In 2018, in Navtej Singh Johar, another case that Supreme Court looked at, the same issues were brought up, the similar arguments were raised. What lawyers did was take the defeat in Nas Foundation in 2013. Marshall did looked at comparative litigation, comparative jurisdiction in the US, in different countries, what existed, how can we transport it back to India and show that our laws are better, our society has evolved, and these policy considerations need to find place in law. And there came Navtej Singh Johar, which again decriminalized section 377. It was a huge victory, and you can see in a very short period of time the society evolves. So a loss in 2013 nonetheless is not a loss overall. Similarly, at the time of emergency in 1975, there were cases filed across the country called habeas corpus cases, where anyone who said anything against the government that the government did not consider in the interest of national security, that person could be imprisoned without any deadline. Simply put, your freedom of movement would be lost. These cases were brought before different high courts in India. We are a large country. A couple of high courts, 3 to be very particular, said that this is wrong, this is unconstitutional. India does not really believe in such restriction of freedoms, and therefore these have to be set aside. Lo and behold, this also landed up before the Supreme Court. What does the Supreme Court do now? Of all the judges in the Supreme Court, only one said these are incorrect. The freedom of movement, even if the country is in a state of national emergency, is sacrosanct. You cannot take it away. The rest of the Supreme Court judges did not agree. They said that freedom to move is not sacrosanct. When the government wants, in state of emergencies, it can be taken away. Now we're looking at that in 1976. Look at that 41 years later. in 2017, there is a case called Puttaswamy. It's particularly on the right to privacy, but it also considered other aspects. The most interesting thing that you'll see here is Puttaswamy itself says that ADM Jabalpur was not the right law as it was discussed. And interestingly, the Chief Justice at the time in ADM Jabalpur of the Supreme Court was the father of the judge who penned down the judgment in Puttaswamy. So you can see the shift in law over 4 decades is recognizing that the Supreme Court, as the custodian of law, as the interpreter of law, and as the final authority in law, is final but not infallible. So as these laws evolve, the laws of today could be and should be the setback that creates clarity over a period of time. Again, there are examples, multiple examples of how the laws of adultery have changed, how the death penalty doctrine, from being rarest of rare cases to how commutation of even death penalty sentences now in India work over a period of time, because there are laxes in the infrastructure that we provide for the prisoners. Something that I do very often, arbitrations. Again, expansive jurisdiction has moved to courts exercising a great amount of restraint over a period of time. Arbitration is something very similar to you choosing your own tribunal, you choosing your own judges, taking your dispute to a place with mutual consent, with the blessing of the government, where you can discuss it and decide it accordingly based on your convenience. Now this issue is not just in India. This exists globally. When we talk about issues like homosexuality, segregation, discrimination, and abortion, you must have seen and must have read over a period of time, even in the US, these have evolved typically the way India has. So there is something called psychology of loss, and that's not just limited to law. There are 2 ways of looking at a loss. We lost the case today, or I'm a loser. Depending on the day, all of us know I could be either and you could be either. But a factual assessment of the outcome, taking a step back, reviewing where you went wrong, is the most important aspect of recognizing yourself and distinguishing yourself from I'm a loser to we lost the case today. And that's exactly what life also entails. Now, losing beyond courtroom is something that we want to really look at today. Entrepreneurs pivot, scientists also fail in experiments. They discard those theories that did not work for them. Athletes confront delays, and athletes also get defeated at global stages. Yet lawyers occupy a unique crossroads of logic, language, and morality. Why is that? That's because every judgment is public, every defeat could likely be written, archived, and reasoned. And somehow our defeats as lawyers are, to adapt a phrase from T.S. Eliot, measured into coffee spoons and then put along with the sugar day by day. This visibility of loss imposes a higher obligation, and therefore we cannot storm off the pitch like a proper loser, is what we'll say, or a frustrated lawyer at the end of the day. Indian cricket provides us similar metaphors. Losing gracefully, losing with discipline, developing a bone to lose well is what we want to do. In corporate disputes, you need to protect yourself against losses, something that I do. You need to pick the seat deliberately, choose the arbitration law properly, calibrate the tribunal, ensure that what you get out of any dispute, any supposed battle, is enforceable. A paper decree is not very helpful to you. You always have to build a record, create evidence to ensure that you write emails if a tribunal will react to them. Preserve privilege. And when you do look at any dispute, decide like an investor. Post-mortem these issues, think of it backward. Now, what you need to do is win the process instead of winning the long-term monetary loss that could stare you in the face. Don't start a fight to avoid a war. A battle lost and war won are way, way more important as compared to anything else that you do over a period of time. The disciplined art of losing and strategic art of maneuvering litigation is what differentiates us lawyers from sore losers to graceful losers and losers who've learned to lose for a definite purpose, for saving ourselves from a larger war. Concluding what I think is an apt method overall, I started by saying that I don't get paid to lose well. But here's what I really mean. In litigation, scoreboard is only one section. The other screens, like I said, are cash flow, your reputation, time to certainty, customer satisfaction, regulatory posture, and enforceability. You need to determine the future risk. If you define winning as I won every point in court, you're not correct. You will lose more than you know. But if you define winning as we created durable value, you will find that the deliberate, disciplined wins are much, much clearer if you lose on the short term. Thank you so much.